Welcome to the Elk Talk Podcast with Randy Newberg and Corey Jacobson. Presented by the Rocky Mountain Elk Foundation.
The goal is what little you and I know about elk hunting, we share with people.
I've got an elk building. It's like 120 yards away. What do I do? First off, the thought would never cross my mind when an elk's being 120 yards away to call anybody on a cell phone.
All elk?
All the time? Only elk?
Only elk.
Well, it's us having conversations, so we usually go down some rabbit holes, but
If you hunt with Corey Jacobson, you will find the landscape is full of rabbit holes. We're just going to make this up as we go.
and you look at it like, oh, that's a target-rich environment. But if you're trying to single one out, a solo target there is much easier to go into than a big group.
We record everything, so there's no BS and no lying, no faking it with us.
Did we hit the record
I thought I forgot to hit the record button. If you want to know something about elk hunting, this probably isn't the podcast to listen to. Should we give them a list of all the other podcasts where they might learn something? All right, Corey, you said we should start recording this. So I just hit the record button.
Well, thank goodness we missed a good 15 minutes of discussion here.
Did we?
Well, I think so.
Huh.
I was getting pretty fired up.
No, I'm always fired up about this stuff. You should see my library of stuff related to this. There's so much of it that I have spent most of my adult life. In addition to researching elk forage and elk studies, the other part of my life, if you look at my library, is conservation history, conservation law. How did we get to where we are? How did we end up with these state-based systems?
Yeah.
Where do the federal systems apply or not apply? Yeah.
Well, for those who are joining us here and wondering, what are they even talking about? Where did this come from? We received an email.
Yeah.
And the email kind of kicked off me asking Randy a question before we hit record here. And then Randy went into a 20-minute dissertation on case study and case law. And it turned into some really good stuff. And I'm like, wait a minute, we're getting too far into this discussion to not be recording. Let's start this discussion over.
Yeah. So should we say what that email is?
Yeah.
Without ratting anybody out. In our last podcast, or a couple podcasts ago, one of our listeners heard me talk about some Supreme Court cases, United States Supreme Court cases, that use the public trust doctrine to establish state-based wildlife systems. And so this person, being a good advocate and concerned about what's going on in Colorado, goes to their commission meeting and says, "Hey, you can give priority to residents," because he states that his one of their commissioners and their director declared that treating residents and non-residents equally is one of the priorities of Colorado Parks and Wildlife. And then this person gets up and cites a couple court cases that I had mentioned, Martin versus Waddell, Gear versus Connecticut. And he said when he got up there was a commissioner on the Colorado Commission that he says is a bit of an activist, or maybe a lot of an activist. I don't know. And he tells him, look, your court cases you mentioned were shot down and overruled by this case called Hughes versus Oklahoma. And that the public trust doctrines, which established state-based wildlife management, was convenient legal fiction. Well, that commissioners, and so the commissioners like, we don't need to listen to any of this state-based stuff and all the things that traditionally has been the basis for states managing wildlife, because this case overrules everything. It's a 1979 U.S. Supreme Court case. It had to do with minnows. A guy from Texas is catching minnows in Oklahoma, And Oklahoma said, we're not going to allow you to sell those minnows outside of the state of Oklahoma. Well, anyone with much understanding of the commerce clauses and stuff, the U.S. Constitution, the commerce clauses, Article 1, Section 8, the U.S. Constitution, and it gives Congress the power to regulate commerce with foreign nations, with the tribes, and among states, between states. So when a state tries to get that far out in the weeds with their wildlife management, the U.S. Supreme Court said, look, you're allowed to do this state wildlife management thing where, GEAR established that, but you can't do rules and establish laws in your state that affect commerce among other states. And so this commissioner who was just telling, kind of tried to shoot down the comments of our listener, that person is creating legal fiction by saying the Hughes case just got rid of state wildlife management. No, it didn't.
And that's what the listener said. The commissioner told them that the presentation, or during his presentation, that Hughes versus Oklahoma overruled GEAR versus Connecticut, and that the public trust doctrine was a convenient legal fiction. So that's a commissioner on the Colorado Parks and Wildlife Commission,
who is a trustee.
Yep, of the state resource.
Right. Says, I am not a trustee because the public trust doctrine is legal fiction.
Well, and he said that the director of the CPW declared that treating residents and non-residents equally is the first priority of CPW, and second to that is equity.
Yeah, and so he sent us the YouTube link. It was streamed live on March 14th, 2024. The title is Colorado Parks and Wildlife Commission Meeting /Day 2. So this person shows up and testifies and, sorry about that, and does what we hope they're going to do, go and stand up for the things that are important in their state. And then one of the commissioners tries to tell him, and I don't know if this commissioner is an attorney or not, but if they are, I wouldn't get my legal advice from them. I don't think they're an attorney. But it says because of the Hughes versus Oklahoma case in 1979, state-based wildlife established under the GEAR versus Connecticut case of 1896, and the public trust doctrine is nothing but convenient legal fiction.
Nice. You can see whose side they're on.
Right.
I mean, you have a commissioner of the Colorado Parks and Wildlife that is telling us that everything that has been established to manage and protect wildlife within the states is nothing more than convenient legal fiction.
Yeah.
They're not concerned about wildlife at this point.
No. So there is a movement afoot, and that's kind of what gets this out there, is there are movements afoot to try and negate and destroy, or, I don't know if destroy is the right word, but erode the basis for state-based wildlife management.
Yeah.
Because a lot of people want a federal system. They say, look, I live in Chicago, or I live in, urban America. I think I should tell you folks out in the hinterlands how you should manage wildlife. So they're trying to make the public trust of wildlife a national system. And their basis for doing so, part of their rationale is, well, look, we already have the Migratory Bird Act. Well, we already have the Lacey Act. Those are federal laws. We have the Endangered Species Act. Well, yeah. The reason those are at a federal level is because of these things called the Property Clause, the Commerce Clause, and the Supremacy Clause. In other words, they mostly deal with things where we're having treaties with foreign countries, which we do under the Migratory Bird Act, Canada and Mexico and the U.S. And then we have the Lacey Act that deals with interstate transfer of dead animal parts. And the Lacey Act came in 1910, back when they were killing all the flamingos and the brown pelicans and all the wonderful birds in Florida, and bringing them to New York for the hat business. Everyone needed a big, a mounted flamingo on the top of your hat to go to church on Sunday. And so the rationale used was, well, it might have been illegal in Florida, but I live in New York, and so you can't prosecute me. It's not illegal in New York for me to sell these animal parts. So under our Constitution, and this is where if anyone doesn't spend a lot of time thinking about the Constitution and reading it, a lot of the things we deal with are based back to the principles of our U.S. Constitution. So the Lacey Act said, wait, under the Supremacy Clause and the Commerce Clause, the interstate commerce clauses, the Lacey Act can apply at a federal level. So they're trying to say that because we already have some federal laws related to wildlife, that's why we should have a federal public trust where the trustees should be at the federal level, not at the state level. Yeah. That the beneficiaries should be everybody in the United States, not just the citizens of that state. And in doing so, they could easily get rid of hunting and fishing and trapping because, the urban America might carry the day. Well, that's the effort that they're trying to make. That's the effort of them using these statements that Hughes versus Oklahoma got rid of state-based wildlife management. They want to make that the accepted narrative, and it's not. And as much as they can say that, it really comes down to what does the judiciary say on this stuff? Because anything that's not specifically stated in either a federal or state constitution becomes the role of the judiciary to explain or apply the law and the rights of the citizens and the rights of the individuals as protected or not protected or applicable or not applicable to that constitution. So the judiciary ends up being who solves most of this stuff, not a wildlife commissioner in Colorado or not some group in New Mexico that currently is publishing all kinds of stuff about how the public trust doctrine is really a federal-based system. So that's too bad that guy would encounter a commissioner that denies that there's a state-based system of wildlife management.
Yeah.
And if you go and watch that video, the statement was made by a commissioner, starts with a T, Tucson. I'm not familiar with the person. I don't know him, but anyhow. So what does this have to do with elk hunting, right? People are like, what's this mean? Well, we get into these, especially in application season, and especially when draw results come out, we get into these arguments and debates about what's fair between residents and non-residents and the allocation of such. What's fair in terms of the disparity of fees charged and such. And all of this goes back to state-based systems that say the public trust doctrine means that each state has its own public trust of wildlife, and that they have appointed and elected and employed trustees to fulfill the trusteeship of that wildlife to the benefit of its citizens. In other words, the people who live in that
residents
state.
of the state.
Yeah. So a lot of groups just want to say, no, let's not make that a state-based system. Let's make it a federal-based system.
And there's been lawsuits, that I've benefited from in recent years, right, where states have been sued by individuals or organizations claiming, discrimination between resident and non-resident on the hunting front and asking the state to issue more tags so that residents and non-residents are treated equally. That happened in Arizona in, was it 2005?
Yep.
And that was, wasn't it United States Outfitters, I think, that sued the
Yep.
state of Arizona?
Yep.
And because of that, the initial ruling was, yeah, that is not right. We need to go through. And so I received a tag in 2005 in Arizona, not in the first draw, not in the draw process, but when the state was forced to go in and issue non-residence tags so that they had equal number of tags as the residents that had already been given their tags. So instead of, the 10%, say there's 1,000 tags and 100 of them went to non-residents, 900 went to residents, the state had to now come out and issue an additional 900 tags to non-residents so that they were treated the same as residents. That happened in 2005, and then it was quickly overturned and ruled. I mean, I still got to hunt. I still got the tag. 2005 was the season, it upheld, but then it was overturned. And since that point, it's not ever been ruled in favor of giving non-residents equal treatment.
Right. And in fact, I'm trying to remember the law that Congress passed a law shortly after that confirming the right of states and reaffirming state-based wildlife management. And that was trying to remember what law that was. It was passed in 2005 or 6, and it was the case, all this stuff, and so the Hughes case in the interstate commerce stuff is part of what this outfitter George Tallman used as his basis, and so the U.S. Congress actually went in after that. So the Hughes case is in 1979. This lawsuit is in 2005. The Congress actually went and changed that law and said, or passed a law that confirmed here's what states can do. So it's part of the U.S. law. So
for somebody sitting on a commission in Colorado to challenge that after it's been upheld so many times, and not, like you said, not only upheld previous cases, but new laws passed upholding that, it just shows their, like you mentioned, I think the comment that was used in that was the convenient legal fiction. And that's, if anybody's trying to use convenient legal fiction, it's certainly not the states or the hunters. It's those people.
Yeah. So part of what generated that is, or what generated the follow-up legislation is that they also sued Nevada at the same time. But if I remember right, I could be wrong on this, but I think Nevada and Arizona are in different
district courts.
Circuit courts. Yeah, I think one's in the 9th and one's in the 10th. I could be wrong on that, but anyhow, the case against Arizona ended up getting solved in a certain way. Well, Harry Reid, who was a U.S. senator from Nevada, who had a lot of high rank in the Senate, said, "Well, you sued my state, or we're not getting sued again." And so he was the one who sponsored the bill to reaffirm the ability of states to do that. So if someone wants to go get lawyered up and change all that, I guess, hey, that's up to you. Go do it if you feel that that's worthwhile. But for a person sitting on a wildlife commission at this time, I wasn't there. I don't understand every bit of what this person's rationale was for their response, but it surely made made for an interesting comment in the context of somebody who should be aware of their trustee duty as a trustee of Colorado's public trust and wildlife. That's what we were talking about before we turned all this on. And
I
like,
just
whoa,
fact checked
whoa,
you
whoa.
here. Looks like Arizona and Nevada are both part of the 9th district.
Are they? Okay.
Yeah.
So I didn't know if Arizona was
9th
or not.
circuit.
Okay. But anyhow, for some reason the Arizona case was settled, and I'm not sure what happened in the Nevada case, but Nevada did not have to go reissue their tags like Arizona did. And Harry Reid and I think Udall, I can't remember if Udall was from New Mexico or Arizona at that time. They said, no, we're going to reaffirm the state's right here. So I can't even remember what the bill number was. You think I should know that? But
I just remember it very specifically because, I got the rejection letter from Arizona. Sorry, you didn't draw. And then a couple weeks later, got an email saying, oh, actually, you did draw, and we've issued extra tags. And, as exciting as it was to draw a tag, you still have to realize that there were a whole bunch of extra elk tags that had to be issued that year because of that. And then by the next year, it was reestablished that no, that's not how states manage big game. That's not legal. We're at 10%, and states can decide how many tags they want to allow non-residents to hold.
Yeah.
All the way to zero if they want it.
Yeah. I lucked out, and I drew an early rifle tag in Unit 10 that year because of that law. Yeah. I'm like, really? I mean, there was a sense of, man, I don't really deserve this. But what are you going to do?
Yeah.
So, here, take it back. And that year I told my buddy Jerry, I'm like, look, I already drew Nevada this year. If I end up drawing another elk tag, my wife's gonna kill me. And
what was the other elk tag you drew?
I ended up with a Unit 10 in Arizona, because Jerry's like, oh, apply for early rifle in Arizona, you'll never draw, and then you'll get your point, because I didn't want to miss out on getting a point. Well, because of this lawsuit, I ended up with that tag, and I was not a fan of the lawsuit. So this is back in the day, before you could do things like return tags and everything else. So,
well, and I was in my 20s, still mid-20s at the time, and so I just thought, wow, they're giving out extra tags. That's awesome. I got a tag, and now looking back and understanding, because it goes there. There's my journey of education through not only wildlife laws, but just federal versus state issues. I would say that in my 20s, I probably supported, hey, let's take all the federal land and give it to the states and let the states control it. It's our land. It's here. We don't need the federal government interfering. But then, thanks to efforts by you and other people, understanding that that's not the right way to manage land, because it's been mismanaged, and it's been shown, and the track record's there. And we see it still within the last 18 months here in Idaho. There was an attempt to get rid of more valuable state land being sold to developers to develop. And so, there's a lot of things. I think we grow as we become more educated. And so your understanding of a lot of this stuff is incredibly powerful and beneficial to people who live in Colorado and go to meetings like that. You armed them with just enough information to go there and say, hey, this case back in 1896 made it so that we can manage. Well, then they get shot down with some fictional story that's being told by a commissioner who's supposed to know what they're talking about, but they're using that to to serve their own agenda, not as an actual law that's going to be upheld. So now, we arm them with more information, but it's a battle, and we've got to make sure that we are armed with knowledge so that when these things come up, we can go in there and, Randy can't be the only person that's researching this stuff and learning the information and learning the history. And, we can definitely use this platform to help educate people, but we need people who are on the ground in these states that are going to be able to go there and speak intelligently and in an educated manner to be able to educate some of these people who are standing behind their own fiction to try to change. It's not, and hunting is our platform, but it goes way beyond hunting. And these states are using their positions of power to change things that they want, not things that the people want, or that have been already established and fought and decided.
Yeah. So when Reed introduced the bill first in 2005, his co-sponsors were Max Baucus of Montana, Ted Stevens, Alaska, Ben Nelson of Nebraska, John Ensign, Nevada, Mike Enzi from Wyoming, Mike Crapo from Idaho, Orrin Hatch from Utah, Kent Conrad from North Dakota, Ken Salazar from Colorado, Larry Craig from Idaho, Jeff Bingman from New Mexico, Craig Thomas from Wyoming, John Kyle from Arizona, and Herb Cole from Wisconsin. So we're talking about people from all sides of the aisle. I think he had equal number of people from each side of the aisle. In the House, there was an identical bill, but it's pretty simple language of what it said, and I can't remember which version ended up getting passed, but it was only a one-page bill, and it was called the what did they call it? Reaffirming of State Regulation of Resident and Non-Resident Hunting and Fishing Act.
And it was one page. Let's make this very clear so there's not a whole bunch that can be argued in the future.
Yeah. And it says, in general, it is the policy of Congress that it is in the public interest for each state to continue to regulate the taking for any purpose of fish and wildlife within its boundaries, including by means of laws or regulations that differentiate between residents and non-residents of such state with respect to the availability of licenses or permits for taking of particular species of fish or wildlife, the kind and numbers of fish and wildlife to be taken, or the fees charged in connection with issuance of license or permits for hunting or fishing. So it says, silence on the part of Congress shall not be construed to impose any barrier under Clause 3 of Section 8 of Article 1 of the U.S. Constitution, commonly referred to as the Commerce Clause. Voila.
Makes it pretty clear.
So, and this is where we get into this, everyone likes to use the term legal fiction. And that's usually, and I use it at times, and it's like, I hate saying it because it sounds like I'm trying to dismiss a legal argument that's valid. And that's why when I responded to this person yesterday, I didn't want to necessarily say legal fiction, but legal activism. This person, like a lot of people, which is a popular trend right now, are trying to erode and disassemble the Gear was in 1896, so 128 year policy or theory or legality, whatever, for 128 years that we've had state-based wildlife in this country. And a lot of people now say, well, that's not working. We want to change that. No one's listening to me. Well, guess what? If you live in whatever city in America, in some other state, you shouldn't be telling the people of 4 states south of you or north of you or east of you or west of you, how they should do things. You might want to do that. You might get yourself all wound up in a big French-Canadian frenzy over it, but, that's that doesn't mean you're right. So,
Yep.
I don't know. Have we solved anything with all this?
I think so. It led me to, when we start talking about federal overreach into states and
Mm-hmm.
in terms of wildlife and the effects it has on the residents of those states. Today's the deadline for comment on the restoration of grizzly bears to the Bitterroot National Forest or the Bitterroot Mountains in
Yep.
Montana and Idaho. So,
Yep.
once again, somebody sitting in an office in Denver has decided we need to rewrite something and get some grizzly bears in there because we just don't have enough of them in Montana and Wyoming and Idaho.
Yeah. And, a lot of people then say, wait, how can the ESA apply to the states when we have a state-based wildlife? Well, there is, under the supremacy clause, there are things where the federal government can come in when there are conflict of laws between the states that have different ideas, different things. And this is where I don't quite understand how the Endangered Species Act is rooted in the supremacy clause, but every attorney I talk to tells me, well, it's legal under the supremacy clause. I'm like,
Yeah.
Okay.
So, that's how wolves ended up here. That's, and the Endangered Species Act it's especially when you're talking about grizzly bears. You look at the greater Yellowstone area and it's expanded well beyond there. But when we're talking Wyoming, Montana, eastern and northern Idaho, grizzly bears are overpopulated. There are areas there that you and I both have visited and seen the impact of grizzlies there.
Yeah.
And so, you look at it and say, okay, all these areas surrounding the Bitterroot Mountains are overrun with grizzly bears to the point where states are starting to sue to be able to manage them because they're having major impacts. So now they want to take the focus off that and restore grizzly bears to other areas that border where there's already grizzly bears, where the grizzly bears are naturally going to get to anyway. And it just, I don't know. Again, Colorado's a perfect example of, hey, we've seen wolves destroy everything in all these other states. Let's bring them to our state. The citizens vote on it and it passes. And now under the scope of the Endangered Species Act, we're looking at redoing the EIS that was written in the year 2000 and updating it to go down this road again of restoring grizzly bears.
Yeah. So I wish I was more schooled on how that is and how that works. I've never taken on the level of research and thought about the ESA as I have the public trust doctrine and the state-based stuff. So I just know there's some court cases along the way that affirmed the federal government's right under, I'm pretty sure it's the supremacy clause of the U.S. Constitution that there's cases that have affirmed the federal government's right under the Endangered Species Act.
Yeah.
So that's why. And so when people say, well, Newberg, and this is where everyone thinks everything's binary. It's an either or, it's an A or it's a B. Well, it's not always that simple. It's that simple. We just have little decision trees that get us to the end answer. We got an awful lot of moving parts here. And so when people say, well, how can you tell me I have state-based wildlife, but the federal government can do things like the Migratory Bird Act, the Endangered Species Act, the Lacey's Act? Well, all of those are rooted in the U.S. Constitution in one of these other titles or articles. Whereas the state-based wildlife system in GEAR did refer to the 10th Amendment, I believe. I think that's where they said it is a state trustee right, and absent any federal right, it's a state right. And when the case was heard at that time, there were no cases that established it, or no laws that established it. Nothing in the Constitution established wildlife as a federal right. So that's why it's always been under the 10th Amendment. It says if it's not a right granted by the states to the feds, then by default, it's a state right, unless a few of these other articles apply. So that is why you can have an Endangered Species Act that's considered valid, but yet you can have state-based wildlife management and trusteeship. So, boy, I hope no one was driving down the road listening to this dry stuff. They probably fell asleep, and 4 of our listeners probably rolled over down in a rhubarb when we put them to sleep with all this stuff.
No, I think I think it's important that we as hunters individually are as knowledgeable as possible, because we are the ammunition that has to show up and defend this. And if we go there, and this gentleman who sent us the email, who went to this meeting, was armed with as much knowledge as he had, and went there and got shot down and didn't have the ammunition to back up what he was saying that was actually correct. And so, the next step is, hey, let's increase our education so that next time we're able, or not next time, but so we can continue this fight and stand up to these people who are in positions of using authority incorrectly to progress an agenda that doesn't support wildlife management. Yeah.
Well, there are 4 states that make specific reference, and I don't know if you'd call it codifying it. 4 state constitutions make reference to state trusteeship of wildlife, and that their citizens are beneficiaries of that trust. Yeah. Those are Louisiana, Florida, Pennsylvania, and Alaska. So if this person says this whole thing is legal fiction, then he might want to call up those 4 states and say, you better amend your constitution. You came up with some legal fiction there when you adopted your constitution. But I haven't heard anyone suing those 4 states over their constitution. So probably because they know that that's a waste of legal fees. But, oh well. So all that being said, then we get into, I don't know how far we want to go down this rabbit hole. But the year before the case, the Hughes case, was the Montana case, Baldwin versus Commissioner. And now I'm really going to open up a can of worms for you, Corey. Baldwin versus Commissioner was a non-resident sued Montana that said, you're charging us way too much and you're not giving us enough tax. You're discriminating against us, which is a violation of the interstate commerce clauses and all kinds of other things. Well, those clauses of the Constitution exist. Again, this is an accountant maybe getting out over his ski tips here, but they address the rights of citizens under our Constitution. And the court, if I'm going to summarize this properly, pretty much said, well, hunting is not a right granted to anybody under the Constitution. So your right to come to Montana is not subject to these constitutional provisions that you're citing. And it's not commerce. It's people going out and participating in wildlife management and obtaining some food in the process. Therefore, get out of here, Baldwin. You're wasting everybody's time. And so it affirmed the right for the states to do this stuff. Now, there's some attorneys I talked to who say, when state trustees start opening this can of worms called commerce and allocating part of the trust resources to commercial groups purely for the economic value, are they putting the Baldwin case on shaky ground? And you guys in Idaho, you have a outfitter pool of tags.
Yeah.
Nevada has a mule deer draw for a pool of tags. New Mexico has a specific 10% of the tags go to an outfitter draw. So if you talk to some attorneys who like to nerd out on this stuff, they're like, these are trustees elected either at the legislative level or appointed at the commission level, who have decided for commercial value, probably no value that is wildlife management, no value that is really to the overall benefit of the remaining beneficiaries. They've made some concessions or accommodations purely for the commercial interest of this. Well, how are we ever going to defend the Baldwin case that allows us to have disparity between resident and non-resident fees or non-resident tag allocations if we're doing exactly what the Supreme Court said didn't apply? Elk hunting isn't commerce. It's not a right protected under the Commerce Clause or the privileges and immunities or, all the other clauses that people like to claim they're being aggrieved under. Because at the time, the court ruled this isn't commerce, this is wildlife management.
You are opening a can of worms here.
Well, I know I am. But that can of worms got opened.
I know
when these states did this. So
setting aside a certain number of tags for the purpose of commerce,
yep,
violates the very thing that we're talking about.
Well, if you read the Baldwin versus Montana case, most attorneys say the biggest reason Montana prevailed was at the time elk hunting wasn't commerce, therefore it's not a right protected under the U.S. Constitution, under the, all these clauses I mentioned, the Commerce Clause and the privileges and immunities and list them all off. Because that, the court made the determination that elk hunting wasn't commerce. Therefore, all this the stuff that you're talking about, it doesn't apply.
But elk hunting itself is not commerce.
No.
But paying an outfitter to take you elk hunting?
No. Or a trustee ignoring that case and saying, you know what, we're going to take some of our trust assets and we're going to specifically allocate them to one group of people, possibly to the detriment of the other beneficiaries.
Yeah. Meaning, so a non-resident who's coming to the state to hunt is doing so not through a commercial endeavor. But if they go with an outfitter, that outfitter is benefiting by taking opportunity away from that non-resident, is being paid in a commercial endeavor, and the person paying him is now engaged in commercial activity.
Yeah.
So it blurs that line.
It blurs that line. I think that was going on at the time. Baldwin, I believe, I can't remember if he was in the outfitting business or he was a client of an outfitter. So outfitting was going on at the time of that case, but there were no state participation. So the state, once they issued their tag, it's like, if you want to go transact with somebody, you knock yourself out. If you want to go hire an outfitter, fine with us. If you're a resident, you want to hire an outfitter, fine with us. So at the time, there were not state-sanctioned or state programs that took a part of the tags, which are the trust resource, and they did not have programs that allocated them specifically to a group of commercial activities, a group of businesses. That therefore channels a lot of the activity, that economic activity, through that person or through that group. Now, I'm not saying that it's been decided that these programs make the Baldwin case null and void. I'm saying there are attorneys who've brought it up to me that, the states keep getting out there on thinner ice and thinner ice. Every time they do this and they don't have some demonstrated benefit for or conservation purpose for doing it, they are getting out on thinner ice. So
yeah, and this is not, we're not against or for resident versus non-resident hunting. We're not against or for outfitters or do-it-yourself. It's not taking a side here. It's just saying there's a blurred line there that if it gets defined is going to hurt one of those groups.
Yeah.
You can't have your cake and eat it too.
No.
And that's what's happening right now.
Right. So a lot of these programs came into being in the 1990s, 2000s. The Baldwin case was decided in 78. So I don't know what the outcome would be, but I do caution anybody who was willing to listen that when we start getting into these special handout type or these special preference type arrangements with commercial groups, that we're almost asking for it. And so people say, Newberg, then just shut up. Well, what I'm saying is, if we know we've got a weakness, maybe we should think about fixing it before we end up in court. But if no one wants to fix it, and maybe it doesn't need fixed, I don't know. Maybe all the legal minds would say, oh, no, it doesn't need fixed. Fine. But if someone decides that, hey, guess what, New Mexico, I'm going to sue you for your outfitter set aside, or Nevada or Idaho or whoever, and I'm going to do it because you violated everything the court said in the Baldwin case. Well, that's not my fault. That's the fault of whoever that elected or appointed trustee was who came up with the idea, knowing damn well they were probably endangering the system.
Yeah. Or at very best, trying to find a loophole to take advantage of it. Yeah.
Yeah. So,
but that loopholes typically don't hold up under judicial review.
No. So, I don't know. Maybe somebody someday will grab that and go hire an attorney who understands this stuff and says, hey, now that this state, you did this, we're not going to give you the benefits provided under the Baldwin case, because you've said in our state we are going to make this interstate commerce, or we are going to make it commerce, and therefore because it's commerce, it's protected under the U.S. Constitution and all these equal footing and commerce clause and everything else. So
does Montana have set aside now?
No,
they don't.
We got rid of it through a ballot initiative in 2010, I believe. Yeah. We used to have 40. I think it was 40% of our non-resident tags were through outfitters. So that came about in like 2002 or 3, and it only lasted 7 or 8 years, and then a ballot initiative reversed it and said, nah, not doing that. And that's when I became aware of the issues related to the Baldwin case and set-asides for an economic group, a group who are businesses. Back when that was all going on, I was spending way more on legal fees than I was on hunting licenses. My wife would be, boy, you must have been spending a lot on legal fees, because I saw what you were spending on hunting licenses. But I went to the firm that actually represented the state of Montana in the Baldwin case, is based here in Bozeman. And so the attorney who argued that case in front of the U.S. Supreme Court, I hired him. I think it was in 2004 or 5. And he gave me, I don't know, 30 pages of dissertation about that and a whole lot of other stuff related to the public trust doctrine and trustee duties under all these cases. He brought up, the Hughes case. He brought up all this stuff. And this guy is a genius. He's a legal genius. He also represented Montana when we came up with our stream access law under the public trust doctrine. So he knows his stuff. And he had some cautions for me. And one of those cautions was, the hunting world better be careful. If they want to make hunting or make part of the conservation aspects the commercial activity and use certain groups to conduct that commercial activity that really could be the conservation part of it could be accomplished without the commercial group.
And with the commercial group,
but with the
compromises
yeah. So he cautioned me against that. He's like, that's the reason I was able to help my client, the Montana Fish and Game Commission, prevail in the Baldwin case, is we didn't have any of this stuff. But even in 2003 and 4, it was starting to pop up. So it's not me making it. I guess the reason I give that, Corey, is I don't want people to think this is me making it up either.
Yeah.
I went and hired, and it cost a lot of money. But it was worth every bit of it because I learned so much in my meetings with him, and then his if you want to call it, treatise that he sent me. It was, I think it's some of the best money I ever spent in my knowledge and understanding of how all this came to be, how it applies, and how to try to keep my eyes open going forward. So.
Yeah, the hard part is it's almost a catch-22 in that I'm not against outfitters.
Me either.
They're a business. They're a necessary business. The problem becomes when they are given access to a resource that has been set aside for the citizens of the state or protected through the citizens of the state. They are bringing a commercial aspect into that. That commercial aspect then puts us in jeopardy of being able to manage it through the state, because the reason the states are able to keep their access to the management of that resource is because it's not considered commercial
activity. It's considered wildlife management.
Now you bring a commercial component into that, and somebody could come in and probably argue that, hey, this needs to be equally distributed. It needs to be given out, not based on residency, not based on price, not based on anything. It needs to be given out equally because it is being commercialized. And the other thing is, we talk all the time that hunting is conservation. Hunting is what the states use to manage wildlife. To conserve wildlife, to make sure wildlife is here for 10 years, 20 years, 50 years, 100 years. This model is working. And now you throw commercialization into it, and we can't use hunting as management anymore. That's not the argument that's going to be used. It is hunting is commercialization. Hunting is being used to drive profits through this commercial group, and therefore you're no longer able to say we need to hunt to manage or to have a hand in conservation. So it's a slippery slope both ways. Outfitters aren't going to be happy with us bringing this up and them potentially being the bad guy in all of this, but hunters aren't going to be happy that because, and let's make sure it's clear, outfitters are not the problem. Outfitters getting tags from the trustee set aside for them is the problem.
Right.
So a non-resident applying for and getting a tag or buying an over-the-counter tag and taking that tag that he got on his own through the process that everybody goes through and then going and hiring an outfitter, totally perfect.
Knock yourself out.
Great.
Yeah, do it.
But when that outfitter gets a handout that's taking from our resource, that's where things get really messy.
Yeah. Now, I'm gonna. My mind is going back to all that I learned from this guy. And part of the reason I hired him was there was a push at the time to bring transferable landowner tags to Montana. And in my mind, I'm like, look, this violates everything I understand about the public trust doctrine. You can't take a trust asset and grant it to one class of people through a landowner tag. And he told me, he's like, Randy, I get what you're saying, but if you're the trustee and you have inaccessible wildlife, because no one can access that, but the trustee can make an evaluation that if I grant one bull elk tag, and I'm going to make this, and he used overly dramatic examples to make his point. I think it worked. It sure worked with me. He said, if I'm a trustee and some landowner comes and says, you know what, I have 4,000 bull elk living on my 200,000 acres. If you give me one bull tag, because I live out of town, I'm a non-resident, and I can never draw, and but you give me one bull elk tag, I'll let 50 Montanans come and shoot bull elk on my property. And I'll let 400 people come and shoot a cow elk on my property. He said, if you're the trustee and you can make that measurement and you can quantify how much benefit that provides to the trust and to the remainder of the beneficiaries, he said, I'm going to flip that on you, Randy, and say you'd have to sue that trustee for not taking that deal. I'm like, ooh, never thought about it that way.
Yeah.
He said, the problem is there's no accountability and there's no measurement of the benefits derived versus what's given up in these programs. He said, that's really what you're here talking about. He says, this is what concerns you, is trust assets are granted with nothing in return, no access, no higher objectives, no public ability to participate in that. And so if done improperly, it looks like you're just giving away trust assets to somebody for no good reason and getting nothing in return. And when I say you, I mean the trustee is doing that.
Yep.
He said, but I could sit here under all these laws I'm aware of, all these legal theories, and I could almost make a case, and he used that when we were sitting in the chair across from him. He said, if someone did that example I gave you, if you had a wildlife commission that rejected that, a 1 for 50 bull elk and 400 cow elk, would you feel that trustee's doing his job? I'm like, well, no. He should. One tag is worth 50. One bull tag is worth 50 resident hunters getting to go and 400 cow hunters getting to go. He's like, that's my point. He said, you're able to measure what the trust and the beneficiaries got in return. But if you just throw it out there and there's no accountability, there's no management, nobody's doing anything to contribute to the trust corpus, the wildlife, then you can't determine whether the trustee made a good decision or not. So he said, a landowner tag in and of itself isn't necessarily the problem. The problem is the trustee has not attached strings to it to make sure the trust and the beneficiaries get something out of it that's worthwhile that they would not have access to or ability to enjoy absent the relationship with. And then we were on the topic of landowner tags, but you could probably get into other mechanisms and other programs. But so, some people are going to be like, Newberg, I thought you didn't like transferable landowner tags. I thought you have guests on your podcast that are against that stuff. I'm like, yeah, because I want to have these discussions about, is the trust and are the beneficiaries getting a fair deal out of this? And as these programs proliferate, what we find is usually it's just, well, that's what we've always done. Well, as a trustee, you need to measure, is the trust and the beneficiaries, are they getting something out of it? If not, you better rethink your strategy.
Yeah.
And I don't know, maybe all these states that have these programs, maybe they've had that analysis, maybe they've discussed it. So I'm not saying they have or haven't. I'm just saying that was part of what I hired this guy for, and he opened my eyes by using a really, an example that probably would never happen. But he opened my eyes to the concept that, you know what, Randy, you might be wrong. If the trustee can get the best deal possible for the beneficiaries, not that doesn't make it wrong.
Yeah.
So anyhow, I can't believe it. How did we get into all this stuff, Corey? We're supposed to talk about elk hunting today. You got a baseball game you got to go to, and
I know I brought up an email that we received after our last episode, and it turned into an hour-long discussion that I think is incredibly valuable. It might be dry. It might not be near as exciting as talking about tactics to call a big stinky bull elk into 10 yards and get him standing in front of you slobbering, but we're going to lose those opportunities if we don't educate ourselves and make sure that we are protected, because we've lost too much over by being either too lax in defending what we have or not understanding how somebody else could come in and take away what we have. And I think that, the information age, the information is out here. It takes someone like yourself who's hired an attorney to understand it and become super educated on it to share it with the rest of us. But in the case of Colorado, that gentleman who went there, who testified and was shot down incorrectly by a commissioner, now has the information that's needed to be able to go and refute the claims that the commission was making and be able to say, no, you're actually wrong. Your argument here is proven wrong by this and this, instead of that commissioner going home and being like, we pulled one over on him. He doesn't even know what he's talking about. Now he knows what he's talking about. And he and the rest of the citizens of Colorado can take that information and use it, hopefully, to educate the commission that, hey, we know you aren't on our side, but that doesn't give you the right to go and make up legal fiction here. Yeah.
So the reason he has that information is yesterday I spent a good part of the afternoon replying in an email, because I can't spend this much time on every email we get, Corey. But this guy, I'm like, hey, you've jumped into it. Here it is on YouTube. Someone shooting you down. It's part of the public thing. I wanted to give him everything possible, so I sent him stuff in length and a summary of what Hughes did or didn't do, and what still applies or doesn't apply. So I hope it was helpful to him, and I just admire him standing up and saying, hey, you got to listen to us. You got to behave like a trustee.
Yeah.
A trustee can't ignore this stuff. Well, evidently you can. And here's one of the problems. The only remedy available to beneficiaries is through the courts.
Yeah.
And so if you got a trustee who's not behaving themselves or acting improperly, acting in a manner that's self-dealing, or acting in a way that's impartial towards influence caused or provided by his friends or her friends, or there's these impartiality standards to trustees. So if you got a trustee that's doing all that stuff, it's not like you can walk up and say, hey, quit that. They're like, if you don't like it, sue me. So
well, and the problem is when you have the director and commissioners who are saying that residents and non-residents need to be treated equally. That goes against what's already been established as law. But they're spewing that as doctrine, as this is the law. You don't have a right to discriminate between residents and non-residents. And for some of us, like, well, we don't know the law, so I guess they're right. So then the commission goes and makes a change, and then it's too late. It's just almost impossible to dig our way back out of that. So we've got to be educated to be able to fight this when these things come up, and when we have directors and commissioners who are not looking out for the best interest of the residents, who are not acting in the correct role as the trustee,
Yep.
and who are going to have an impact on hunting and the future of hunting in every single state, not just Colorado. Don't think this is just, look at Washington, what's going on there. There are issues that we have got to protect and that we have got to be educated on. And so I think this episode, as dry as it may have been, it's at the very foundation of protecting what we talk about and what we love to do, and that's elk, hunting, habitat, and other wildlife.
I hope so, Corey. And I haven't been able to pull it up here. I was trying to log on to my my QuickBooks and see what I've paid in legal fees just in the last 2 years. Every time an issue comes up, like in Montana, we have a lawsuit where a group called United Property Owners of Montana is suing our Fish and Game Commission for improper management, not given enough latitude or whatever to landowners. Mostly they're funded mostly, I believe they claim to be represented by a lot of non-resident landowners, and so I went to this law firm. I'm like, can you guys review their case and tell me if it's worthwhile, because I'm going to sue. I want to be an intervener. So the amount of money I spend on legal fees, getting legal opinions, it's probably not smart, but I just feel that if I'm going to be informed on this stuff, right, I'm not going to get my information on this stuff from, I don't care, Instagram or I go and hire people who live it, breathe it, do it, and know it. Yeah. I'm just looking in 2023. It's embarrassing what I spent on legal fees.
And here we are giving it out for free your sacrifice on the financial side to gain that information and then share it is invaluable.
Yeah. Well, I always tell people that as a general rule, free advice is worth what you paid for it. Sometimes it's worth even less than that. And if I intend to be informed, I intend to have information and consume information that is true and correct, and at least to the greatest extent, not disinformation. Well, I got to pay for it. And I pay attorneys, I pay consultants, I subscribe to, I have a ton of subscription things. And I know a lot of people are like, I'd never pay for that. I can get that for free out on, Google or Yahoo. Well, that's probably worth what you paid for it.
Yeah.
So, anyhow. But I know don't you got a baseball game you got to get to?
I do. Sam is pitching tonight, and so I'm going to head down and watch him pitch. Cool. And so,
all right.
Hit the road.
You go right from basketball to baseball.
Literally. In fact, they started baseball practice the last week of basketball season. So there was some overlap, and we went to state and came home, and 24 hours later, Sam's at baseball practice, and they had a game, I think 4 days after that. So it went straight from basketball season to baseball season. But the good news about baseball season is, well, not the good news, but one of the good things is we get to travel a lot to warmer climates, because we've not had a home baseball game for the last 2 seasons because our baseball field's been covered by snow the entire season. So it gets us out of the mountains and down into the valley where there's green grass and about 15 degrees warmer sunshine. So not all bad.
Well, you have fun with that. I'm sorry to have spent so much time today nerding out on this stuff and probably opening so many cans of worms. I can't imagine how many emails we're going to get when this one drops.
We're going to hear from people on this one. Hopefully it's mostly positive. I mean, there will be feathers that have gotten ruffled, but as a general body of hunters who are concerned about the future of hunting and wildlife management, these are important issues.
Yep. I want, when I'm long in the dirt, I want to make sure, my goal is hopefully that all the opportunities I've been blessed to enjoy, those are still available for the people yet unborn, as Roosevelt would say, those in the womb of time. And these are topics, these legal issues, and all these theories and doctrines. These are what a lot of this is based on. These opportunities we have are based on a lot of this stuff. So
Yep.
I want to discuss it. I want to talk about where we're maybe jeopardizing it and what we do to make sure we keep it intact. So
Absolutely.
All
Well,
right, Corey.
if anybody is still listening, thank you for joining us on this episode. Let us know what you think. You can just go to elktalkpodcast.com, click on the contact link, and send us a message that way, and we will absolutely get it. And if it is a really good one like this one, it may be worth an hour discussion on a future episode.
All right. Thanks for being here, folks.
Yep. Catch you next time.